This is Bloomberg Law with June Grasso from Bloomberg Radio.
The Supreme Court kicks off its new term on Monday. The justices are coming off a blockbuster term with several highly controversial decisions that divided the justices down ideological lines. The court continues to face criticism and calls for reform after ethical controversies. And public trust in the court has continued its downward slide to historic lows. Several blockbuster cases involving transgender rights, ghost guns, and online pornography are already scheduled for this term, but it's shaping up to be less contentious than last. At least so far, more cases will be added to the docket. Joining me is former United States Solicitor General Gregory Garr, the global chair of the Supreme Court and appellate practice at Latham & Watkins. Greg, the Supreme Court's coming off this blockbuster term. Some highly controversial 6-3 decisions. There are continuing calls for reform. Public trust is on a downward slide to historic lows. And some of the justices themselves have publicly expressed concerns about the court. What's on the line, if anything, for the court this term?
Well, I think a lot's on the line. Every year for the Supreme Court is a big year. As you say, there's been some clouds surrounding the Supreme Court recently, and so they've got to go back to work, and they've got to, as always, work on building and sustaining the public trust. And they've got 28 cases so far, which is light as the docket's been in recent terms, but things always heat up in October, and we expect that the court will add to its docket, and for all we know, there could be election-related cases down the pipeline as well.
Let's take a look at some of the cases that are coming up, starting with a few cases that are going to be argued next week. On Tuesday, the justices will hear arguments in the case of Garland versus Vanderstock, a high-profile case involving a challenge to the Biden administration's regulation of ghost guns. Tell us about the issue here.
So the court has taken a number of gun cases in recent years, and they sort of fall into two dockets. One set of cases involves challenges under the Second Amendment and the individual right to bear firearms. And the second involves more traditional administrative law type challenges where the argument is that an agency has passed a rule involving guns that exceeds its statutory authority. The ghost gun case falls into that latter category. As you noted, it involves a challenge to 2022 regulation by the Bureau of Alcohol, Tobacco, and Firearms that defines kits that are sold with parts that can be used to assemble a gun in as little as 30 minutes. And the rule says that those kits qualify as a firearm under the Gun Control Act and can be regulated as such. And that's important, the government claims, because the guns, once assembled, lack serial numbers, and so that's why they're known as ghost guns. So this case is a lot like the bump stock case that the Supreme Court decided last year, Garland versus Carhill. In that case, the court invalidated a rule regulating bump stocks as going beyond the technical definition in a statute barring machine guns. So we can expect a very technical review of the part kits and ghost guns in this case and whether that assemblage qualifies as a firearm under the Gun Control Act. The court previously entered an order in this case allowing the government to reinstate the rule while it was being litigated, but Justices Thomas, Alito, and Gorsuch and Kavanaugh all dissented from that, which means that the Chief Justice and Justice Barrett likely hold the controlling votes in this case.
The Fifth Circuit upheld the lower court's decision to strike down the regulation. What was the reasoning there?
Again, this is a statutory interpretation case, and it involves the technical terms of the statute, including the particular parts, the frames and receivers, and whether or not the agency's interpretation of that is reasonable in light of the statutory definition of firearms. I mean, it's a gun case, but it's really a conventional statutory interpretation case.
Considering that the court threw out the federal ban on bump stocks, I'm wondering why they took this case, which is similar.
Well, it's a different issue, and it's a very important issue, according to the Solicitor General, who asked the court to take this case. So in light of that request, it's less surprising that the court agreed to hear it, and I think all agree that the issue is quite important.
Can you read anything into the fact that the court is allowing the rule to be enforced until it's settled at the Supreme Court?
I wouldn't read too much into that, June. Now that the case is before the court, I think the justices will take a close look at it. I think what is significant is that in that prior order, you had 4 justices dissenting. So you can expect that those justices are probably skeptical of the rule as it arrives at the court.
The justices sidestepped a lot of appeals over the Second Amendment, including challenges to bans in Illinois on assault-style weapons, federal bans on firearm possession by felons. Do you think they're taking a break from the Second Amendment?
I think some of them would like to take a break from the Second Amendment, but the cases keep coming. The recent decision a few terms ago in Bruin, sort of reestablishing the framework for evaluating Second Amendment challenges, has created a lot of litigation. There's more cases in the pipeline, so I think whether anyone likes it or not, I think we're going to see a stream of gun cases arriving at the Supreme Court.
Now, next week on Wednesday, oral arguments in a death penalty case, Glossop versus Oklahoma. And this goes back to 2004, when Richard Glossop was convicted of murder and sentenced to death. 9 execution dates have been set for him, and he's had his last meal 3 times, according to the Death Penalty Information Center. It seems as if over the years the case against him has fallen apart in many ways.
This is truly someone who has had almost 9 lives already. So he was sentenced to death for a killing at a motel in Oklahoma City a couple of decades ago, in which the case really turned on the testimony of one individual who worked at the hotel and who said that Richard Glossop paid the man to kill the victim. And what makes this case really interesting today is that Glossop's challenge is now supported by the people who sought the death penalty against him, the prosecutors, Attorney General in this case, of Oklahoma, who now agrees, based on newly discovered evidence, that Glossop conviction is tainted by constitutional errors, including a very important Brady error. Brady is the decision in which puts an obligation on the prosecution to come forward with exculpatory evidence in criminal cases. In this case, the claim is based on the prosecution's failure to turn over exculpatory evidence that bore on the credibility of the state's star witness. Again, this man who claimed that Glossop paid him to kill the victim. The Oklahoma Court of Appeals refused to set aside Glossop's death sentence, even notwithstanding the Attorney General's own confession of error in the case. The Supreme Court, which hasn't taken many death cases in the past few years, granted review. So now it'll be really interesting to see what the Supreme Court does as it reviews Glossop's claims of constitutional error, again with the Attorney General of the state separately represented arguing alongside Glossop. And then looking in the background of this case is the interesting question of how courts should treat a state's own confession of error in a decades-old case. On the one hand, you would think that would be a pretty compelling reason to re-examine and perhaps set aside a conviction. On the other hand, there have been, some concerns of political considerations that could enter the mix as you go from one administration to the next, so that the court's going to take a close and fresh look at this case.
The court's not going to consider all the alleged errors by police and prosecutors, but just that prosecutors didn't turn over these handwritten notes, that the state's key witness was suffering from a serious mental disorder.
Yeah, that's exactly right. There are a lot of claims in the case, but the Supreme Court's review here is going to focus on that Brady error, which involved the failure to turn over those notes, which Mr. Glossop claims could have been used to impeach this witness whose testimony the case, I think both sides agree, basically turned on.
So the Supreme Court, as you mentioned, hasn't taken many death penalty cases recently, and there's a history of finding that state convictions should remain final, even if there's later evidence that they may be unreliable. The Supreme Court, in a 6-3 decision last week, allowed Missouri to execute a man for a murder, even though his conviction was contested by prosecutors. So no matter how strong the evidence, if they stick to the idea that state convictions should be final, will it make any difference?
I think you're right, June, that the court has been hesitant to overturn state court convictions. And in a way, it has to be because of the statutory law governing habeas corpus and the like. But nevertheless, here there are clean constitutional claims of error, including Brady. And that's something that justices on both sides of the ideological spectrum have taken very seriously. And the fact that this is a death case only raises the stakes. So I think if the court looks at this record and agrees there is constitutional error here, I would be surprised if it didn't take some form of corrective action. But there's no doubt that those challenging death sentences face an uphill battle before the current court.
So now, perhaps the highest profile case so far on the docket involves a polarizing issue across the country, Tennessee's ban on gender transition care for minors. Tell us about the issue here.
So this is really the one big culture war case that's currently on the docket right now, and it involves a challenge to a Tennessee law that bars gender-type medical procedures or treatment for minors, including surgeries and puberty blockers and hormone treatments and the like. And it's a law that 21 other states have enacted right now in similar form. And several individuals backed by the Biden administration itself have challenged the law on the ground that it rests on a sex-based classification that violates the Equal Protection Clause. The Sixth Circuit upheld the law below. Supreme Court granted review, and the key question now is whether the law triggers heightened scrutiny under the Equal Protection Clause or instead the much lower rational basis review. And that turns on whether you view the Tennessee law as making a classification based on sex or instead one that is based on the regulation of access to medical care and that acts on an even-handed basis among minors, regardless of sex. And what's interesting about this is that question implicates a case from a few terms ago, Bostock versus Clayton County, in which the court, in a closely divided opinion written by Justice Gorsuch, joining with the more liberal justices, held that Title VII's prohibition against sex-based discrimination applies to sexual orientation. So the U.S. argues that the reasoning of Bostock leads to the conclusion that laws concerning access to gender treatments are sex-based, in the sense that one who is male at birth can get testosterone treatments, but a female at birth can't. Whereas the state argues in this case that the law doesn't draw any distinction based on sex because it simply applies to all minors and bars access to these treatments in the case of gender-type procedures for all individuals, regardless of sex. And then lurking in the background of this case is a debate over the medical importance of these treatments for those seeking access to them, which could well color the legal arguments on both sides of the case.
You mentioned that about 24 states have laws restricting access to therapies like this. So could this decision establish a landmark legal precedent?
I think it's going to be quite important because this is one of the early cases in which the court has confronted the issue of transgender rights and, laws drawing classifications of this type. So although I suspect that the court's decision will be, focused on the Tennessee law at issue here, I think it could have long-term implications for laws and actions dealing with this important question.
Coming up next on the Bloomberg Law Show, cases involving flavored vapes and e-cigarettes, environmental rules, and securities fraud lawsuits. I'm June Grasso, and you're listening to Bloomberg. The Supreme Court's new term starts on Monday, and I've been talking to former U.S. Solicitor General Gregory Garr about some of the noteworthy cases the justices will be deciding. Another case involving minors is Free Speech Coalition versus Paxton. It's about age verification for pornographic websites.
So Texas enacted a law that says that any website that publishes pornographic or other harmful material must require users to verify that they're 18 years or older in order to access the site using various forms of virtual IDs. And the argument that the plaintiffs brought in this case is that the law violates the First Amendment by burdening adults' rights to access the material on such websites by basically making it more burdensome or cumbersome to have to show an ID or the like to get onto the site. The Fifth Circuit upheld the law and the Supreme Court granted review. This is another case where the big question is, how strictly the court has to review the law. Do you apply strict scrutiny or the much lower form of review rational basis? And that turns on the court's reading of a 55-year-old case called Ginsburg versus New York in 1968, in which the court held that the states may restrict minors access to pornographic material. But in more recent cases, including a case 10 years or so ago in Ashcroft versus ACLU, the court has subjected laws restricting adult access to websites and the like to strict scrutiny. And this court has established itself as very pro-First Amendment and arguably as one of the most pro-First Amendment courts in the court's history. So it'll be interesting to see how it analyzes this law.
So the Supreme Court in April refused a request by the challengers to halt enforcement of the law while litigation in the dispute proceeds. Every time they do something like that, I say, does that indicate where they're going here?
I mean, of course, if the court really hates a law, it's going to prevent it from being enforced. So that's a strong indication it's not going to get a favorable reception when it arrives. But it's a really high standard to invalidate a law during litigation. And so I think that's, one sort of tea leaf. But I think that in itself is unlikely to tell us much about how the court would resolve this case. So this well could be a case that involves an interesting lineup and a narrow decision.
So another case from the Fifth Circuit. This is about the FDA's efforts to curb flavored vapes and e-cigarettes.
And here it's a challenge to the FDA's defense of its rejection of the applications by two companies who sell flavored vaping products. And the FDA declined the application, as it has done for most similar applications, because of public health concerns stemming from the use of flavored vaping products and the attraction of minors. And so the companies argued here that the FDA had violated the Administrative Procedures Act by acting arbitrarily and capriciously, in that it engaged in sort of an unfair surprise by changing the rules for evaluating these applications in midstream without fair notice and improperly refusing to consider certain evidence. It was something of a surprise that the Fifth Circuit here, broke with other courts that had faced similar challenges in finding that the FDA had acted unlawfully in disapproving these applications. And so I think that this, could be a sleeper case, and it's definitely an interesting case to follow because it's really more of a nuts and bolts administrative law case than sort of an e-cigarette case. But a decision by the Supreme Court in this case upholding the Fifth Circuit, I think, would invigorate arbitrary and capricious challenges to all sorts of rules. And one thing that we've seen in the past few years, as you know, is the Supreme Court taking an intense interest in administrative law cases and really sort of pushing back on various aspects of the administrative state, capped off last term, of course, in the decision overturning Chevron deference.
Yes, I say the court has taken a sledgehammer to agency power, perhaps a too intense description there. But what could be the implications of ruling against the FDA in a case like this where health of children is concerned and, the FDA's authority over health concerns in general? Or is it just about the standard of arbitrary and capricious?
In a sense, it's broader, June. I think it does raise public health implications of allowing these sorts of products, which FDA is regulating. Of course, if the Supreme Court affirms the Fifth Circuit here, it doesn't mean that the applications would be granted. It would mean that the FDA would have to go back and take another look at them, presumably. But the broader implications here are if the Supreme Court agrees that the agencies acted arbitrarily here, then I think what it would mean is that courts would have to take a much closer look at agency decision-making and claims that agencies have changed the rules sort of in the course of an administrative decision-making process. That's the sort of claim that agencies, typically had won a decade or so ago, and it's tougher sledding these days. So I do think that this is a really important case to keep our eyes on.
Next, let's turn to a completely different area involving standards for investor claims in shareholder lawsuits. NVIDIA versus E. Oman J. out of the Ninth Circuit.
So this is a technical securities case. The question is whether the heightened pleading requirements of the Private Securities Litigation Reform Act apply to allegations of security fraud based on internal company documents, such that plaintiffs seeking to establish scienter using company documents have to allege the actual contents of those documents. And the question tends to come up when securities plaintiffs claim that a company's internal documents contradict its public statements that the company's executives and the like are making to investors, but oftentimes, or sometimes at least, the plaintiffs don't actually have their hands on the documents, so they're making allegations based on what they surmise are in the documents. In this case, the plaintiffs claim that the CEO of NVIDIA, a company that manufactures computer chips, made public statements at odds with the company's reports about whether crypto miners or gamers were buying their chips, which became important when NVIDIA's revenues dropped after the 2018 crypto crash. The plaintiffs argue that imposing a heightened pleading standard in this context is at odds with the PSLRA and the court's prior precedents. And the Supreme Court, though, in prior cases has generally sort of rigorously enforced these heightened pleading standards. There's a related question that comes up in this case, which is interesting, which is whether a plaintiff can rely on expert testimony itself to establish the falsity of internal documents based on an assumption of what the information the documents contain. So that'll be one we want to follow as well. You know, the backdrop of this case is that business really has had something of a mixed record before this court in the past few terms. This is not a court that is reflexively ruling in favor of business, and so it will be interesting to follow this case and see where the court ends up here.
So a decision here could give companies leverage for earlier dismissal of shareholder lawsuits?
Exactly. If the heightened pleading standards apply to these sorts of claims and internal documents, then it's going to be much harder for plaintiffs to bring claims based on internal company documents because they often don't have access to the full contents of those documents.
Next, let's discuss a case on water pollution and the EPA's powers. And this case involves San Francisco versus the EPA, which is not one of the cities I would expect to go against the EPA. So tell us what San Francisco's case against the EPA is.
Yeah, it's kind of an indication of where we arrived with aggressive environmental enforcement, where you've got San Francisco itself taking on the EPA. So this case arises out of a permit issued by EPA under the Clean Water Act for San Francisco's discharge of sewage into the Pacific Ocean. And the question is whether the Clean Water Act authorizes EPA to impose general water quality standards on San Francisco and other jurisdictions for the quality of the receiving waters, as opposed to specific what's called effluent limitations on discharges. San Francisco itself taking on the EPA. So San Francisco argues that the Clean Water Act was intentionally designed to enable EPA to regulate what was coming out of the pipe, or what's known as point sources, through these effluent limitations, which impose specific limits on particular pollutants. And that, EPA is sort of changing the game when it's trying to impose general water quality standards on the regulated, which then is much more abstract and difficult for jurisdictions to comply with. But EPA says not so fast. EPA says that the Clean Water Act can't be interpreted that narrowly, that although it refers to effluent limitations on discharge, that it also allows EPA to regulate water quality in other ways. The case really boils down to whether EPA's interpretation violates the Administrative Procedure Act on the ground that it contravenes the statute. Now, this is exactly the sort of thing to which EPA would have asked for and received Chevron deference a decade or so ago. And after the Loper-Bright decision last term, though, it's going to have to fight this one out on a level playing field.
And do you think that Loper-Bright and the courts, I'm going to say, tendency to eliminate environmental protections or to rule against the EPA? I mean, last term they split about blocking the EPA's good neighbor ozone emission rule. I mean, do you think that bodes ill for the EPA here?
I think it could. I mean, there's been something of a perfect storm where you combine aggressive agency enforcement with reliance on broad statutory provisions, which is where what we've seen come up time and again in these cases. And if that's the way the Supreme Court views this case, then EPA may be in for a fight.
Thanks so much, Greg, for joining me again in our yearly preview of the Supreme Court term. That's former U.S. Solicitor General Gregory Garr, a partner at Latham & Watkins. Coming up next, why deals are collapsing. This is Bloomberg. The Biden administration is touting the fact that so many potential deals are being abandoned under its policy of pushing for fewer settlements and more lawsuits. Firms attracting antitrust scrutiny are abandoning deals at their highest clip in years. 6 significant merger inquiries during the first half of the year ended with the Federal Trade Commission or the Department of Justice saying the parties nixed a proposed transaction. That figure exceeds yearly totals from the previous decade, according to a report from the law firm Deckert. Joining me is William Kovacic, former chair of the FTC and a professor at George Washington University Law School. I wanted to start with getting your first reaction to the report that firms attracting antitrust scrutiny are abandoning deals at the highest level in years.
My sense in talking to friends who are counseling companies is that's true. It's very difficult to judge how much and which deals are being chased off. On the one hand, the commitment to litigate cases more broadly, plus a variety of other policy adjustments that basically take settlements out of the picture or make settlements harder to achieve, not impossible, means that at the margin, more companies are deciding not to proceed with deals. And that's not just a function of the U.S. regime. If it's a company that does business, say, in the European Union, in the United Kingdom, or is a global goods and services company, the risk associated with going forward has increased in the United Kingdom and in Europe. And that means that you not only have to cope with the additional cost, delay in the United States, there is the certainty of additional reviews in other countries, so that when firms are looking at the path they have to take in order to achieve the result they have in mind, that is a more perilous path than it was before. And at a minimum, it is a path that is slower and more expensive. And I think at the margin, that's discouraging companies from even pursuing certain types of deals, in part because when they turn to their internal advisors, their own internal counsel, or to external counsel and say, will this deal get through? They're being told it is highly unpredictable. It's very risky. It's risky both for the buyer, but certainly for the seller as well. And that additional risk, I am certain, is scaring off some transactions. It's hard to tell how many.
So the Biden administration has touted these trends, but do the numbers mean that the deals are anti-competitive and so the firms are abandoning them, or just because they don't want to, as you say, go through litigation with the government or this long review process?
Yeah, part of it is that in the past, where there was a perceived problem, even if the company thought the problem didn't exist or was trivial, it was possible for them to negotiate with the FTC or the DOJ a settlement to solve the problem either with divestitures or with behavioral commitments. That flexibility has been largely wrung out of the system, where although the agencies are not completely unwilling to accept settlements, and we saw Chevron and Hess accept such a settlement only just recently, the government agencies have said, by and large, we think settlements don't work, that even structural solutions are often ineffective. And as a consequence, because we don't believe they work, we're willing to go to court and try and block deals rather than negotiate. So even where a competitive problem existed, until the relatively recent past, the government agencies were willing to bargain and to accept settlements. That flexibility to a large degree has been taken out of the system, which means that even where companies recognize that there was a competitive problem, they've lost the ability to negotiate with the government to find a solution. Or if they really want the deal to be done, they have to be willing to go to court and argue to the court, we have a solution in place to solve the problem and to persuade the court that that solution is effective.
So, as you say, Jonathan Cantor, the DOJ's antitrust head, and FTC Chair Lena Khan have said they are skeptical that settlements or consent decrees work. Do you think they work? I mean, even if they don't work, do you just give up on them completely?
I think that their concerns are somewhat exaggerated, that the concerns they've expressed are not baseless. There is a history of failed settlements in a number of sectors. There is always a danger in settlements that for the sake of building up numbers of enforcement events and moving matters through the system, both the parties and the agencies will step forward to the world saying, we accepted a solution that protects consumers. I've never read a press release from a government agency in the U.S. or abroad that said, we accepted the settlement, but there are real risks here. And if you want to watch whether or not this works, you should focus on the following factors. That press release is never written. The press release always says, we spotted the problem, and like the most skillful surgeons you ever saw, we intervened to take out all of the anti-competitive possibilities. The patient of competition is alive and thriving. We are the most successful competition hospital on the earth. That's the way the settlement press release reads. But that often is a fiction or not quite right. So Assistant Attorney General Cantor and Chair Khan are exactly right that we should perhaps be more wary about settlements. But there's a spectrum of options that range from absolute skepticism and doubt to a more critical point of view that still accepts the settlement. And here, I think, is what's lost in the process, is that let's suppose that you have a settlement that gets you 90% of where you want to be. That settlement allows you to move more resources to focus on deals that are manifestly anti-competitive and deserve litigation challenge. If you take away the flexibility to take that 90% solution, it means that you better be willing to fight a much larger number of deals for which you do not have the resources to carry out all of those battles, or you are going to find quiet and more subtle ways to let deals go through that may involve some informal conceptions, may involve you wading through deals that are not so visible, that aren't tech, that aren't food, that aren't energy, in order to keep your statistics balance sheet clean with no settlements, but with prohibitions or clearances being the main option. So I think their expressed concerns are somewhat exaggerated, and I don't think that they quite respond to the reality of what decisions an agency has to make when it has a continuing flow of filings where you have some transactions that are going to be problematic, a lot or a little. You need some flexibility to accept deals for transactions that pose a more modest competitive risk, where the settlement is maybe not perfect, but it might be good enough in order to allow you to mobilize resources to focus on deals that are manifestly problematic, for which you have to pursue the settlement. So to some extent, I think that they have denied themselves an element of flexibility that is very important to making the entire merger review process effective.
So, Bill, can you talk a little bit about how they've also stepped up enforcement in areas that previously they didn't look to so much, like labor and potential competition and vertical mergers?
They've unmistakably highlighted the importance of competition in markets for labor. And antitrust law for a long time has recognized that competition for labor inputs is very important, but it hasn't elevated those concerns as much as the agencies have. That happened in the DOJ Simon & Schuster transaction, where DOJ relied very successfully on essentially a labor market theory of harm. The most interesting of all the labor cases, I think, is the Albertsons-Kroger transaction, where, to an extent not previously seen, the FTC has elevated the role of labor as a key input, has highlighted the impact on organized labor of the transaction, saying that the transaction will deny unions the ability to bargain as effectively as they might otherwise. That transaction is the most interesting test of the effort of the agencies to extend the frontiers where labor theories of harm are important. Unmistakably, they've also demonstrated their willingness to litigate vertical merger theories of harm more than the agencies had in the past. The Trump administration did challenge the AT-Time Warner deal unsuccessfully, but that was a major effort to focus on vertical theories of harm. The FTC and DOJ have had success, some failures, but success as well. The FTC's challenge to Illumina Grail, vertical transaction where the FTC was largely successful. What's happened is that the agencies, because of their skepticism of settlement, have cast aside the previous practice of resolving vertical concerns by taking settlements. It's not as though the agencies before 2020 or before the AT&Time Warner deal ignored vertical issues, but those vertical issues usually were resolved with settlements that imposed behavioral controls on the firms, especially controls that said that you won't discriminate against third parties with respect to access to an asset or an output that you now control. So what we've seen is what's interesting and distinctive about the modern practice is that the agencies have been willing to litigate those deals to block them. Again, not with complete success, but firms now realize that a vertical merger is much more likely to show up in the courtroom in a litigated challenge rather than result in a somewhat predictable behavioral fix. That means that vertical deals are riskier now than they used to be. And on the question of nascent competition, both agencies are approaching the acquisition of upstart firms or smaller firms with interesting ideas with a lot more skepticism than their predecessors. They believe that a grievous failure of antitrust policy in the previous decades was not to bear down on acquisitions by established incumbents of smaller upstarts. So they've decided that, especially for big tech, that acquisitions of small upstarts in a variety of different areas could pose a competitive threat, both because the upstart has the capability to grow into an independent source of rivalry to the incumbent dominant firms, or that the upstart has a complementary capability which, when added to the portfolio of the incumbent, gives it a greater ability to resist entry and expansion by other firms. Now, those theories of harm have been somewhat harder to establish. The courts have been somewhat more resistant to those theories, in particular because they feel the government has lacked proof that shows that the acquisition of the nascent threat is likely to be harmful. They accept the theory that the acquisition could be harmful. They haven't repudiated the government with respect to the theory, but they've said, you have an interesting hypothesis about what might happen if this smaller upstart firm is acquired. Do you have more facts to show, to give us confidence that that hypothesis is likely to be true?
Finally, the Biden administration formalized its enforcement approach in merger guidelines. What's your take on those merger guidelines?
The merger guidelines unmistakably stake out a broader perimeter of enforcement. They embrace a wider range of theories of harm. They announced that the government will review horizontal mergers at lower concentration thresholds than they had announced that they would in the previous guidelines issued in 2010. They spell out greater skepticism about efficiencies as justification for mergers. So in a very general way, the 2023 government merger guidelines announced a decided effort to extend the frontiers of enforcement beyond the boundaries at which they've been set, certainly since 2010. The real effect of those guidelines and all government guidelines depends on their absorption in the courts. The guidelines are important as an indication of what the government means to do, but it's only when federal judges look at those guidelines and say, these make sense as a principle for merger control, and adopt the reasoning in published opinions. There are several cases now in litigation that will give judges an opportunity to do that. Albertsons Kroger is one. The Tapestry Capri case is another, involving accessories, handbags. The Tempur Sealy mattress merger case is a third that's in litigation. There are a couple of others at the fringes of litigation now. Those cases are interesting to watch because they will tell us how rapid this rate of absorption is. You need a critical mass of district judge or court of appeals opinions that say, we don't have to follow these guidelines. They don't bind us, but we find their reasoning compelling, and we are going to embrace and rely upon the analytical approach that they set out. So over the next 18, 24 months, we will see if that judicial uptake is happening.
Thanks so much for sharing those insights with us, Bill. That's William Kovacic, former chair of the FTC and a professor at GW Law School. And that's it for this edition of the Bloomberg Law Podcast. Remember, you can always get the latest legal news by subscribing and listening to the show on Apple Podcasts, Spotify, and at Bloomberg.com/podcast/law. I'm June Grasso, and this is Bloomberg.